Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elawvate.net, ELAWVATE.net, or go online to elawvate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elawvate.net or fill out a case workshop request at elawvate.net. And Rahul and I will look forward to chatting with you soon. It's time to talk about some of our sponsors, and I'm doing that today with Robert Ingalls from LawPods. Today's episode is brought to you by Steno. Steno is a company that has rethought court reporting services. Not only do they allow plaintiffs' trial lawyers to defer the cost until the end of the case, but they've developed their own interface that allows you to better handle and manage exhibits and visuals during the deposition. Check them out.
And what is it about Steno that you really feel like is their main thing? What makes them special?
You know, I think it's really critical for lawyers to have that option to defer the costs of depositions, particularly in cases where you're doing dozens of depositions. It can be a very significant part of the overall case costs, and it's nice not to have to incur that until you get your money in at the end of the case.
And you can listen to the Season 4, Episode 17 with Steno President Dylan Ruga. We'll link that in the show notes for you.
Yeah, Dylan's a great guy and a really interesting episode, so I encourage you to listen and see what they're all about. Our show today is also brought to you by our friends at Expert Institute. They've been a sponsor of this show since the beginning. My good friend Michael Talvey was on the show, and Robert can tell you when that was. What was his episode, Robert?
So we had Michael Talvey on Season 4, Episode 22, and we'll link that one for you as well.
Yeah, and Expert Institute is really the go-to place now for plaintiffs' trial firms to locate the best experts to help them win their case. We've been working with Expert Institute for 4 years now, and they're an indispensable part of our practice. It's really hard for me to imagine going back to a day without Expert Institute. So they're a great company. They provide a great service, and I would encourage you to try them out. Today's show is also brought to you by Smart Advocate. Smart Advocate is the case management software that we use to run our law firm. We've been using it now for over 4 years. All of our staff and our team love it, and it's done a great job managing a complex docket of cases. Some cases are one-offs. We have cases where we have over 100 clients, so it's pretty versatile and a good program and good people. We also had them on the show, right, Robert?
Yeah, I think we may have had them more than once, but I think the most recent episode was with Claude Simpson. It was a bonus episode in Season 3, which will also be linked for you.
Our show today is also brought to you by Filevine. Filevine is a brand new sponsor of the show, and Filevine offers a product called Lead Docket, which is probably the best product on the market for managing new case intakes and leads. And if you're a law firm like ours that spends any dollars at all marketing to bring cases through the door, you know how important it is that you don't want to miss any of those, and you want to have an organized way to make sure your team follows up with every lead and turns any potential case into money to bring money back in the door. So Lead Docket is the best way to do that. Check it out and put it to work in your practice.
And I couldn't help but notice you have a shiny new website at GideonAsin.com. Who does that for you?
So our friends at Hype Legal, Micah and Tyler, we just hired them to redevelop our website. They did a wonderful job. The aesthetics are beautiful. The coding is really slick. They do a great job. It's a real pleasure to work with Micah and Tyler because unlike many of the other digital marketing firms, when you work with them, you deal directly with Micah and Tyler. You're not dealing with some young account executive that doesn't know anything about coding or your business. You're dealing directly with the principals. They're very responsive, and they've got a great eye for aesthetics. So check out our new website if you like it. Give Micah and Tyler a call, and they can do the same great work for you.
And I got to say, I'm hearing people say that somewhere around episode 2 of this podcast, it just started sounding a lot more crisp, really good, really professional. What happened there?
You know, it's funny you should ask that, Robert.
I'm the worst.
So we decided finally after 4 seasons of kind of winging it, and we did an okay job, but we thought we could do better and get better sound quality, have a better produced show. So we finally bit the bullet, and we've hired LawPods to be our official producer. So not only they've been editing the show, but now they're also producing it. So you can thank the better intro, the better outro, and the better sound quality to the great folks at LawPods. And if you're a lawyer who's interested in putting together a podcast for yourself, I would definitely give them a call. They can help you out.
All right, I think that's our ads. Let's get back to the content.
Welcome to the Elawvate podcast. I'm Rahul Ravipudi.
I'm Ben Gideon.
Ben, okay, let's just quickly talk about cold plunges. We've got a stark disagreement here. I guess I'm from a warm weather state and you're from a cold weather state, but why do you believe in it so much?
So I started doing these cold plunges probably 2 months ago. It's life-changing, Rahul. You really got to give it a shot. And I know that your colleague and partner, Brian, is a big believer in it. So, you know, it's got to be real. It's got to be good. It just makes you feel great, causes a dopamine release. It's like people that are alcoholics or quitting smoking, they will substitute a cold plunge because it gives you the same rush that you get from doing those kind of drugs. And it's a great way to start the day. I just did mine about an hour ago, and it makes you feel good and gets you ready for your day. So I highly recommend it. It can be a little painful to get into that cold water, but you won't regret it.
I don't know.
There you go. There's the sales pitch on it.
Life-changing. Yep. I'll agree. I bet it is life-changing, but I don't think in a positive way.
A month from now, you're going to be doing it. I know you will. By the way, I'm really happy to see the Lakers are back with Luka and everything and LeBron. I didn't know how that was all going to work out, but it's so far so good.
I'm still scratching my head on how we got Luka. This is amazing.
Well, we'd like to welcome Bradley Cosgrove to the podcast today. Brad is an exceptionally talented and accomplished trial lawyer from Chicago who works with Bob Clifford at the Clifford Law Offices. He's had a number of, just so many. If you get onto his bio, it's head-scratching multi-million-dollar verdicts, including one he got recently that we may get into and talk about. But what's so interesting about Brad is that unlike many lawyers who kind of grow up with it, we had Scott Schlesinger, growing up with a dad who was a trial lawyer, and the whole family kind of thing, the Koskoff family. That wasn't your experience, was it, Brad? You didn't grow up with a family of lawyers.
No, our upbringing was a little bit different than that. We grew up in the household with a Chicago fireman as dad at the house, and education was not a given for everyone in the family. In fact, the majority of my 20 plus family members ended up not being college graduates, and there are a lot of college graduates, but not a given. My dad was one of 10 children. His father passed away when he was about 4 or 5 years old. His mom was left as a widow with 10 children and a stay-at-home job, and was living off the Chicago Firemen's Widow and Pension Fund, which is a very small pittance that no human really could live on. And my dad kind of, as a fireman, did his thing, but also kind of made it one of his career paths to try to be heavily involved in the Widows and Orphan Fund of the Chicago Fire Department for his whole life, and try to make that better for people that were in a similar situation to him when he kind of grew up. The long and the short is, no, my dad was not a trial lawyer, and that's not how we grew up. We grew up with different types of arguments at the house.
Your dad, but also many of your siblings and relatives are members of the fire department, right?
My brother's a captain on the fire department currently. My dad was a fireman. My godfather is a fireman. His dad was a fireman. Literally, my family is littered with firemen, and I did not follow that path. As the baby of the family, I've got 6 brothers and sisters. As the baby of the family, I actually thought I wanted to be a teacher, and ended up really wanting to be a trial lawyer. Kind of my earliest memories of being in this business is dating back to when my mom and dad actually were in a really bad car accident on Martin Luther King Day in 1991. And my dad broke his back. My mom had a closed head injury and couldn't recognize who I was for a long time. And my first memory of being in the courthouse was my mom and dad's jury trial against a trucking company who hit and ran over my mom and dad on their way to work.
How old were you at that time?
I was 10 at the time of the crash and 11 at the time they went to trial. On my golden birthday, my dad had a 20-hour surgery where they removed a part of his back and took part of his hip and moved it into his back, moved his lungs and his heart out of the way to fuse his back from T3 to T5.
What do you remember about that case? Did it turn out well for your dad? And how did the lawyers do? Were you actually in the courtroom, and did you watch the trial?
So I went to the Dirksen Federal Building in Chicago for the trial, and my earliest memories were not actually being in the trial, but actually standing outside of the courthouse that I practice in today, still today, standing outside of the courtroom at the courthouse, waiting to go in for opening statements with my dad and my mom and their lawyer, who was a gentleman by the name of John Ambrose, who ended up giving me my first job when I was in high school, where I started answering the telephone and running and picking up checks for him on kind of a small personal injury firm in Chicago, where I stayed until I got my current job. I went through law school and continued working there all the way through law school, through being a lawyer. And in my first year of practice, I was lucky enough to get an opportunity to try a case where I got $1 million verdict on a case. And then within still that same year, maybe within the first 2 years, I ended up getting another verdict on a malpractice case that was $1 million verdict. Kind of got my name on the radar, and a few years later, Bob Clifford came and made an offer to me that I couldn't refuse, and the rest is history.
Was the offer you couldn't refuse just come work with me?
It was come work with me, and a lot of other stuff like unlimited resources to do what you want with cases, access to some of the best experts in the world, the ability to work with what I think are the finest lawyers in Chicago, and a platform to kind of build my brand in practice with the firm, to have no limitations to my vision of how I wanted to practice. And I had asked in the interview, I don't know, interview might be a little too much, but during the discussion, I said, I don't really want to come and take a job where I'll be holding somebody's briefcase and showing up and being a glorified second chair for a bunch of people that are really qualified and really great lawyers. I still wanted to be able to try cases. And the promise that was made to me, which actually came truer than you could ever imagine, was that is not our intention. Our goal is to support you, and the things that you're good at, we're going to let you continue to be good at and hopefully be great at. And the things that you're not good at or not great at, we're going to support you and give you all the support that you need so that, we could fill in any weaknesses that are in your legal practice to, make you as effective as possible. I kind of thought about that, and I was like, oh, that sounds really great. Let's see if this happens. And lo and behold, I had everything that was promised was given and more, and kind of worked out as a perfect marriage. And I don't think I could be happier with the circumstance and opportunities that I've gotten. As a young lawyer, I've literally been on trial every month or two since I started at Bob's office, and nothing changes. We start another trial 21 days against Monsanto for a Roundup in non-Hodgkin's lymphoma trial in March 24th.
How long?
We had a trial that was supposed to start on March 10th for a medical malpractice case for a gentleman who died of a pulmonary embolus that we were lucky enough to get resolved and settled just last week. So I'm supposed to be on trial regularly, and I've got all the support I need and feel like I'm a lucky man.
Why are people still trying cases against you, Brad?
I don't know the answer. Malpractice cases are cases that have consent policies, and oftentimes I think the consent process is taken more for granted than it is really used as a way to protect clients from the defense bar. I don't think the conversation, the come to Jesus moment, if you will, with medical malpractice defendants come early enough so that doctors consent so that cases can get settled earlier in the process. I really believe that that's a limitation of why cases, specifically malpractice cases, go as long as they do. Because insurance companies, at least from a bad faith standpoint, can sit back and say, well, it's a consent policy and the doctors didn't consent. Therefore, we had no obligation or opportunity to negotiate the case any sooner.
What's your favorite part of trial?
Voir dire.
Yeah, why?
I'm not the person that likes to sit down and talk about Paul's graph and sole proximate cause theory and the Supreme Court said this. And, I read the restatement of torts by, this person or that person. I think people usually laugh and make fun of me around the office because they call it the restatement on Cosgrove, because I said, well, if that's not the law, it really should be the law. From a legal scholar standpoint, I don't very much love that aspect of the practice. I like the everyday human, regular people where you get to talk to people and, try to put your case on. And voir dire is the best place where, normal people can meet, hopefully, a normal lawyer, and you could kind of set yourself apart from others where you could just sit down and look people in the eye and have a conversation like you're at a bar or at a church gathering or Bears game or whatever, and kind of get a gist for who you want and who you don't want and gain some rapport and take off running.
Do you use jury consultants?
We do use jury consultants. We've used a number of different jury consultants over the years. I have a couple favorites that I like to use, probably in the tons of juries that I've picked, which from a verdict standpoint, I think sometimes you get gypped on the amount of verdicts that you have compared to how many juries you pick. Because just think about like how many times you'll pick a jury, you'll open and the case will settle, or you'll get through the plaintiff's case and the case will settle. That happens a lot in Chicago. I don't know about in California or where you guys are, but we get out to trial a ton. And we pick a lot of juries and a lot of cases will resolve. So long story short, to answer your question directly, I use a lot of jury consultants and we use them in preparation for trial. We use them for focus groups, but to actually sit down and pick a jury, I would say a small majority of my cases we've utilized a jury consultant to pick a jury. I kind of have my own rubric of how I think about those things.
What is your approach to jury selection?
At least as far as malpractice cases go, which is what we're going to talk about, is that you really need to look out for a certain few type of people. The worst jurors for us are the shit happens jurors, excuse me for swearing, but the shit happens defense is a real defense in a malpractice case. And I think you can get a gist of understanding from people if they're going to accept that, Jesus, doctors are good people, they're trying to do good things, and sometimes bad shit happens to good people, and just because there's a complication doesn't mean there's malpractice. That's a very real bias of a juror that we deal with. And the most important thing I think in voir dire is that you got to be able to spot the shit happens jurors and get rid of them.
And how do you do that?
Do a lot of focus groups, pick a lot of juries, and it kind of just stands out to you who those people are. It's kind of like, what's that Supreme Court case? Not to get back into legal scholarship, but where they said, what's obscenity? And know it when you see it. The shit happens people are the ones that'll say, like, can I give you a couple examples of questions that I think can ferret out the answer? I'll ask every juror in a case, can you give in your experience, have you had good or bad experiences in the medical field? We want to hear about them. And then people him and haw, and I'll say, here's what we really want to know. Do you have any particularly good experiences? Something along the lines of, this doctor saved my dad's life, and I really feel that I'm obligated to the medical community because Dr. Smith saved Dad's life, and I saw what he did, and he worked miracles, and it'd be really hard for me to sit down and listen to a case. So I want to hear about good experiences like that, and then I want to hear about bad experiences where, you thought the medical care didn't stand up to the standards you had in your brain. And that's what I want to talk about. People will generally talk. And what you'll get is someone who'll go, well, I didn't have a good experience or I didn't have a bad experience. My mom did go to the hospital and she died there of an infection, and we got her there with a fever of 105. But, old people die sometimes, and, that happens. And then, and they go on. And you think to yourself, like, okay, he just told me something that objectively we might get 5 calls a week on, right? And you're thinking to yourself, why are there 5 people who will call and think that there's malpractice for their family, but this guy's just saying, no, I don't, this just happened, and he won't even call it a good or a bad medical experience. He'll just throw it out as part of his, the fabric of life coming into the trial. And I think you could take from that at least a little bit of a background of understanding that this guy is susceptible to the defense. My follow-up question that I ask actually every single juror, and I try to look them in the eye, and if your jurisdiction will allow you to do it, I look at them and I'll say to jurors, if you were a victim of medical malpractice and you were seriously injured, would you consider going to a lawyer and have them investigate the circumstance? That's a really decent question to kind of bring out the people that are shit happens defendants, in my mind. You will get, at least in Chicago, you'll get 80% of people that'll say, yeah, I'll investigate it. But you'll get one person that's overly analytical, and you'll get someone to say, well, it's really hard to bring lawsuits. It's really hard to bring a lawsuit, and you need to have lots of resources. And, that overwhelms me or that scares me. And people who just can't commit, at least from my perspective, I think that's a really important question. And then the last part of the shit that happens defense kind of rubric in my brain. By the way, I didn't think we were going to talk about this today, so I'm just kind of talking. If you want me to stop, I will.
This is wonderful.
The last part of the shit happens defense that I really think about is the jurors that have a higher level of burden of proof that needs to be proven in cases. Time and time again, you'll do a focus group, you present a great case, and your jurors will talk, and you'll hear them in deliberations. And what they'll deliberate about, and what you'll hear them say is, I know Dr. Gideon was great, and he tried, or wasn't great, and we don't like him, and we think he should have done more. But he didn't intentionally do this. He wasn't grossly negligent. And because of that, I think I'm going to go with the defense. And no matter what we say the standard is, if we call the standard negligence, simple negligence, willful and wanton, whatever it is, there will always be a level of jurors that apply a higher burden of proof and want you to have to prove intentional misconduct or willful and wanton misconduct. And I think it's super important to be able to spot those jurors, because no matter what, you're never getting them on your side. They're verdict form B people no matter what. And you need to be able to parse out who the higher burden of proof people are. Because if you listen to a focus group time and time again, the one person that's holding out or the two people that are holding out are higher burden of proof people.
Yeah, that rings so true in light of my recent experience too, and debriefing jurors post-trial and seeing what happened. You can see how those particular jurors sabotaged the result.
What I try to do is I ask jurors, ladies and gentlemen, does everybody understand this is a civil case, not a criminal case? And you always get somebody who will be like, yes, I understand. My hope is in the veneer, there'll be a juror who sat on a criminal case. And kind of my stick is to say, hey, Mr. Smith, you sat on a criminal case. You understand that this is a civil case. This is not a criminal case. We're here on a civil case for money damages. Nobody's going to prison. Nobody's getting punished. This is a case for money. Does everybody understand that? You get a lot of people like, but this is a money case. Does everybody get that? Everybody okay? And the judge will tell you, and I think that it's super important, in a criminal case, has anybody ever heard that the burden of proof is what's more probably true than not, that you need to prove something beyond a reasonable doubt? Has everybody heard that? You heard that on television? What would you do if I told you that in this case, you can't use that standard? Would that make you uncomfortable? Would it make you uncomfortable that in this case, you would have to use a different standard, a lower standard, simply of what's more probably true than not true? Would that make you uncomfortable with trying to decide how much money to give in a case? You had to decide what's just more probably true than not true. Meaning you could have, and I argue this in closing, you could have reasonable doubt in this case and the plaintiff still wins. You could have serious doubt. You could have considerable doubt. You could have all kinds of doubt. But that doesn't mean the defense wins just because you have doubt. It's totally okay for you to sign a plaintiff's verdict with reasonable doubt and we still win. Doesn't that feel uncomfortable? It feels almost wrong to say, but that's what the law is. All you have to do is prove, in this case, what probably happened. What is more probably true than not true? Can you sign a verdict at that lower standard only of what's probably true? Not that they intentionally did it, not that they grossly were negligent, not that they did something, that was reckless, but just that it was careless. Could you do that? Could you sign a verdict for someone who's just careless? And you usually will weed out someone who philosophically doesn't like that concept. And you could just see it on their face, or you could see someone who will look down and look over and go, God, who else is with me on this? What kind of law is that? And then nobody will say something. I'll try to call on them and be like, hey, sir, I can see you look like you weren't very happy about that. Tell us your feelings. That's my gist. Sorry, I think that derailed.
No, not at all. I mean, those are a lot of the hot button issues. We do get to ask that question of, and at the heart of it, of your first area of inquiry was, would you even consider calling a lawyer and investigating the case? Those are people who don't even believe in litigation. So they come in there and they go, this whole process, I don't believe in it. And if they don't believe in the process, they haven't even gotten to the shit happens part about it yet. You've already lost them, which is a really good call in identifying those people.
I think, too, when you ask the questions, if your jurisdiction will allow it, always say if you were a victim of medical negligence, if you're a victim of X, Y, and Z, would you hesitate? And the word that always gets the jurors, at least from the way that I've done it, is that they'll talk about hesitation. I'm not even trying to see if they're willing to do it. I just want to know if they'd even hesitate to look into it. And you'll get people that'll go, well, I'll hesitate, but maybe if my wife made me do it, my brothers told me we should do it, I'd look into it for my mom. But, I might have some hesitation. The word hesitate, for whatever reason, I started doing it like maybe 10 years ago, and people catch on to using the word hesitate. And that's like the springboard for conversation. So I try to use the word hesitate every time because it seemed to work for at least Midwest jurors. That's like the springboard to talk.
I like that.
That's just been my experience.
We're going to circle back to the recent verdict you had, but going back, so you start your career as a trial lawyer. In the first year, you get a couple verdicts over $1 million, which is, I would say, pretty rare for brand new lawyers. How did that happen? Is this just something you're naturally gifted at? Because usually there's a steeper learning curve.
There is a steeper learning curve, and I look back and think to myself, if I would have handled those cases today, what I did when I was 26, I think the client would have been a lot better served. But, we did win, and who knows, maybe it would have been the same verdict. But I really think it has to do with opportunity, and hard work. I always had, and I still have, the mentality that nobody is going to work harder than me, and nobody's going to know a file better than I did. So I literally immersed myself in the case. If I was going to be on trial, I worked from 7 o'clock in the morning until midnight every night, and, had a regimen that I just would never be outworked, and put literally every ounce of effort I possibly could into the case, and kind of willed my way through it as a young lawyer. Maybe some ignorance of not knowing what you know and some false confidence kind of blend together to help. I wouldn't say talent. I'd say maybe ignorance was probably a stronger trait at that time. I had tough cases. They were not like the greatest cases that I was trying as a beginning lawyer. They were kind of the cases that other people didn't really want to take out to trial, and I was willing to try literally anything. So I opportunity and willingness to try cases, a couple good successes, and you kind of just take it from there. My advice to any young lawyer who will listen is, if you can get out to trial, do it. If it's a third chair, do it. If it's a fourth chair, do it. If it's a first chair, drop everything in your life for it, because it could change, change your entire career path. I'm a professor at, I don't think professor is the right word. I teach trial advocacy at UIC's law school in Chicago. And like 3 nights a week, there's a trial team that comes to my office, and we work on trial programs. And I tell the students in the course literally every single week, any chance you get to be involved in a trial, be involved. Anyone asks you to write a brief, write a brief. If you write a brief, next thing you know, they might ask you to sit in the audience. Next thing you know, from there, you might be sitting behind the counsel table, and next thing you know, you'll be given an opening statement. So don't ever pass any opportunities. Try to stick your nose everywhere you can to get an opportunity to try cases. And, that was my springboard.
You were talking earlier about there's certain things that you excel at and certain things you that are your weaknesses. I got that the law may be one of them. But is there any?
Well, the restatement at Cosgrove, I'm actually pretty strong on. At least the second edition. The restatement of conflicts is maybe a little bit more complex in my brain. I don't think you want me doing like legal briefing and writing. I don't have the skill set to, write complex legal briefs like some other people. There are people that are just better at it. A very good idea person, but not very good at writing, and not very good at sitting down and being pinned down to my computer for 4 days at a time trying to write up a brief. That's kind of like being across the Hades River for me.
What's your thought on you? So you start to learn a file, especially now. I bet you get lots of files that are coming across your desk if you're prepping for trial every other week. And how quickly do you start to see the finish line and what the themes are in a case? Here in medical malpractice, Monsanto, you got all sorts of cases that you're dealing with.
That's a great question. And I would always say that my goal is always to have a theme and theory by the time I'm going to give an opening statement. But I'm always willing to kind of like move it around and reconsider and retool all the way up until it's go time. I even think from a standpoint of voir dire, while you want to have some elements of your theme there, I have a fairly standard way that I like to do voir dire. I have kind of a complex way of trying to get to the jurors that I like to see on our panel. I pretty much follow the same voir dire basic strategy normally. I will pepper in some theme and theory related stuff, but by the time you're at trial, I definitely have got all that lined up. Sometimes, like I said, I will work with some jury consultants. There's some terrific people out there. I don't know if you guys have ever worked with Eric Oliver. I very much like working with Eric Oliver on story and trying to figure out the presentation of evidence of how you're going to present a complex legal and chronologic story that can just be a persuasive story instead of like a legal chronology. I think all too often us lawyers, I've been guilty of this, will get up and give an opening statement on a case that's a legal chronology. And then on X date, Y happened. And then on the following day, this happened. And the way it's presented is in the fashion of a chronology as opposed to a story. I think sometimes we could work with jury consultants to help take us out of the box of being a lawyer and help us tell stories so that our stories are persuasive and then we could pepper in the facts. I think that's really been the place where I've used jury consultants the most, to go back to one of the earlier questions. But to answer your question here directly, the storyline of what you're going to tell a jury in opening statements and then prove through the evidence is something that I'm very flexible with, and I'm very comfortable being in flux all the way up until the time you're going to open. That might be unusual. Some people like a lot more certainty.
What causes you to stay in flux? Is it rulings on certain motions? Is it just kind of continuing to get comfortable with the evidence and how it all fits together, the order of presentation?
That's a really good question. At least from my medical malpractice experience, one of the hardest things is you have a perfect vision in your brain of how you want to put your evidence in. Like you say, okay, I want to call my standard of care witness as my first witness, right? But you call your standard of care witness and he's a pediatric cardiothoracic surgeon that can only give you half a day next Thursday, and it doesn't fit in the way you want to present your evidence. And there's nothing you can do to change his availability. And while your perfect world is to have him go first, it doesn't really work that way. And you have to, you kind of have to adapt to the way the schedule fits. And unfortunately, in a lot of cases, the schedule takes precedent over the exact way you want to put in the evidence, unfortunately. The age-old question of when do you put the defendant on, or do you put him on at all? Do you put him in through statements, or do you put him on as your first witness, try to eviscerate the defendant, make the jury dislike him, and then move on and hope that they've forgotten that it was a person by the time of the closing arguments? Does that help you kind of organize your theme and theory? I think it's a little too late by then, but certainly a bad adverse of a defendant as the first witness can kind of change the complexities of what you expect to do later in the trial. I think everybody's been there before.
In terms of your approach to medical malpractice cases or any complex case, where do you see the balance between, like you said, outworking everybody, knowing the file in extraordinary detail, but then on the flip side, being able to translate it into common themes and things that are accessible to ordinary folks on a jury? You seem like someone who would be very good at talking to regular people, using simple language. A lot of times med mal cases quickly become overly complicated and people tend to overtry them. So how do you strike that balance?
I ordered a bunch of books from Trial Guides the other day just for reading purposes, and they sent with the order a free calendar. You guys ever ordered from there? And they send you like this free calendar, and every day you pull off a day, and it has like a quote from one of our trial books in there. And one of the quotes I pulled off yesterday, and I actually left it on my desk for a meeting I had this afternoon, is that over complexity has killed more malpractice cases than bad witnesses. And it's probably extremely more eloquent than the way I just butchered it, but the theory, kind of the theme was there. And I really believe that complexity, and certainly over complexity, is the death sentence of a malpractice case. If you're on a malpractice case talking about technical things that jurors have absolutely no idea about, as opposed to everyday things about, like, should a patient bleed to death during plastic surgery? I don't think you need anyone on your jury to be able to answer that question. It would be no, you should not. If you're trying to ask whether or not, a systolic blood pressure greater than 140 should warrant antihypertensive medications in the face of an ischemic stroke, nobody knows. That's too much information. Nobody has anything to grasp from a personal knowledge bank. And they have to basically rely on your experts, and you're going to have one expert. In Illinois, usually we have one expert on a topic, and then the defense will have 2 or 3 or 4 witnesses on the same topic, because the law allows them to do that. So, you've got 1 versus 4 on a super complex topic. If you're not winning with a common sense argument or something that could really stick to somebody's heart, I think the benefit of the doubt is going to go to the doctor who, when the jurors look at defendant Smith, they're going to say, look, when I'm going to the hospital and I'm dying or my mom's dying, who am I going to have to rely on? I'm going to have to rely on this guy to save her life. And I trust and put all my hope and trust into this person. And what we're talking about here seems really complex and really hard. But at the end of the day, he says it goes one way, the other plaintiff says it goes the other way. I have no idea. So I don't think they've met their burden of proof. Note for the plaintiff, only letters, no numbers, and lots of tears.
Yeah, I don't think, I can't even pronounce half the words you just said in that second hypothetical, and I can't imagine deliberating
I
on
just
it.
made that up as I was going.
Well, that does seem to track pretty closely to your recent case, but I struggle with that too. And I know a lot of that the conventional wisdom, obviously, you got to keep it simple, and we do try to keep it simple. And
But it simple, I think, is an oversimplification of it. I don't know. That's my take. Is you can't, like, you still got to kind of talk about the facts, but you've got to make it like an understandable theme for people to get on board with.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Rahul Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at PSRplaybook.com and learn from the best.
So you've got the defense expert, or in your case, 4 different experts who get up there and they do their dog and pony show for 4 hours, and they're going through the, whatever it is, the blood pressure tables, and they're going through the stuff you just referenced about hypotensive and ischemia and citing all the literature and blah, blah, blah. Now you stand up, Brad, and you got to cross this guy. What's your approach to doing that to keep the thing simple, the themes that you want to elicit, but getting into enough medicine that you can show that these guys are full of it?
I don't think you need to get into any medicine to show that somebody's full of it. If somebody's full of it, they're full of it, and your job as the lawyer is to make people believe that. And if that's based on the fact they're a overly used expert, that's one way. If it's that they're missing facts, that's one way. If they're an Ivy Tower approach, that's one way. If they're the black sheep, these are all kind of my different like themes of cross-examination. So if they're the black sheep, you make them the black sheep. If their position is unbelievable because it defies common sense, that's one argument. And then if you're really right on the medicine and there's guidelines on the topic and it's a literature cross, God help you. Plaintiffs never win a literature cross. If your trial is, did this document say this and this and this? It's just, I always think that the literature fights are tit for tat and nobody ever wins the literature fight. But I don't know, depending on who the witness.
What do you think about if the defense doesn't cross-examine any of your experts on the literature, and then all of a sudden some defense expert says something stupid, and it's not getting into the weeds on the literature? Like, do you see this, multisyllabic statement in this, 35,000 page document treatise, but just the concept of you're saying exactly the opposite of what's in these 9 treatises.
To hear a doctor, a med mal defense expert, ever admit that a piece of literature actually is contradictory to their statement is like a zebra unicorn. No matter what, you can hit a guy with a 3-word sentence and they'll say, but Mr. Cosgrove, like you do with everything, you're taking this out of context and you don't understand the totality of the circumstances. You see, when this was written in this chapter, and then the court will let him go on in the bullshit forever, and a jury will think that, you're screwing around with the literature. Not to tell you I don't do it, and I do it, but basically I don't really, like, here, let me give you an example. I tried a case, I'm going to say the gist of it, I think it was August, September, October, like right in that range. And we got like an $8 million verdict on the case, $9 million verdict. And it was an older lady who died as a result of aortic valve stenosis. Basically, like the valve of your aorta gets too thin or gets too clogged up and you can't pump enough blood out of it. It's actually really bad. It's a bad combination. And the guidelines in the case by the American Heart Association talk about a lot of different topics. I won't bore anybody with the details of it. But the gist of my cross-examination on it wasn't the details of it necessarily. It was the punchline of, you didn't even follow the guidelines, did you? And I don't care what they said because all of my experts would agree they didn't follow the guidelines. And then my essential cross was, you didn't even follow the guidelines. And I don't care what they said afterwards. Over and over and over, I just continued to say, you didn't follow the guidelines. The guidelines, without doing specifics. That resonated with the jury from my memory, is that the fact that guidelines were not followed was all they remembered. They couldn't tell me the exact page, line, and citation of the guidelines, but the accusation, continuous and unrelenting accusation of you didn't even follow the guidelines, was a theme that stuck. So that's like one example of how sometimes I've been successful with literature, but I don't like the literature fight. I don't know. I've seen other people very successful with it.
Switching gears slightly, tell us about your relationship with Bob Clifford and what have you learned from working with him?
Bob is the absolute best. I love working with him and working for him. He's been a terrific mentor. Right now, he's all around the United States meeting with families from the Washington, D.C. crash, and we've been lucky enough to be involved with some of the families that lost their life in that crash.
And what is it? I mean, I know he does a lot of airplane litigation. You've been involved in some of that. That sounds pretty fascinating.
Yeah, right now Bob's the lead counsel on the ET-302 products liability case against Boeing, who was headquartered in Chicago. That is pending in the Northern District of Illinois federal court. There was 159 people that died on the plane crash, which was the second MAX 8 to crash in the world. Following the first Lion Air disaster, this ET-302, which is Ethiopian Air, came a few months after the Lion Air crash for the same defective product. Boeing has admitted liability in that case, and there are still a number of cases pending with our next set of trials coming up very shortly in April. So Bob's extremely active in aviation litigation in the current circumstance because of the huge amount of litigation ongoing in the Boeing litigation in Chicago. And then also there's been a recent rash of unfortunate air incidents that have taken place that have kind of refocused our business model and certainly Bob's time. But Bob, while he is an expert in aviation and has been involved in just about every major commercial airplane crash in the last 40 years, he also has been involved with tons of malpractice cases, truck cases, you name it, he's been involved. Was in New Mexico on opioid litigation, yesterday, involving issues. So he is nonstop. he's really a great role model for everybody, because while he won't ever tell anyone that he works harder than them, he certainly works as hard as every other person in the office still today. And he's awesome. I don't know if that was too much, but.
Can we move to your recent $66 million verdict, right?
No. I gotta make sure that this is clear, because some different people have reported this, and I want to make sure that this is right. It's a $54 million and $1 verdict.
Okay. Sorry about that.
No. Don't be sorry, because it kind of got out with some weird information. There is a prejudgment interest statute in Illinois that added money for prejudgment interest that made the judgment $60-something million, but we shouldn't call it that. We should make sure that we call it specifically a $54 million and $1 verdict.
Well, tell us the story, our listeners, the story, because it really is an amazing example of how trial law, civil trial law, can try to right what is a horrible wrong and a systemic problem that's actually to date affected a lot of people, caused a lot of death and mayhem, and without some check on this would continue to cause death and mayhem going forward.
This is a terribly unfortunate and tragic case that came into the office, and the family came and met with us pretty shortly after the case happened. We met with them in the office, and what happened is my client went in to get a tummy tuck. She was 39 years old, a mother of 4, and she wasn't extremely happy with how her midsection looked and wanted to consult a neighborhood doctor for improving her appearance, which had some challenges, and there were things that we were concerned with going into the trial. But the gist of the story is she wanted to try to help make her midsection look a little bit more slimming and attractive, and she went to a plastic surgeon who was about 6 blocks from her house by the name of Ayub Sayegh. And the consultation was for a tummy tuck and liposuction. Let me tell you a little bit about Sayegh, if I may. Sayegh is a plastic surgeon who was trained in Michigan at Wayne State University, got out on his own, began practicing, and apparently went through some kind of family issue or domestic issues in Michigan. And part of his divorce, there were issues in Michigan, and he decided after the divorce that he wanted to kind of branch out and open an office in Chicago. Kind of unusual. Most of the plastic surgery places in Chicago are kind of in the highfalutin, fancy pants neighborhoods where people are rich and want plastic surgery. And this operation was different. This was within a few blocks of Midway Airport in a predominantly Hispanic neighborhood, where Dr. Sayegh came to Chicago with the plan and intention to market himself as the cheapest plastic surgeon in town, or the lowest, most affordable plastic surgeon in town. And he kind of marketed himself excessively, or heavily, I should say, on TikTok and Instagram and Facebook, trying to find certain population of patients who were looking for what I think he called affordable plastic surgery, which you'll see in some of his other advertisements he called the cheapest plastic surgery, or the least expensive, maybe is the more politically correct way of saying it. Long and the short of it is he advertised on some of the Spanish networks and had ads in Spanish that ran, and my client drove by the plastic surgery office multiple times and ultimately decided she's going to go in and get a consultation. So she got a consultation, and she didn't have money to pay for it, which is very common for this guy. Dr. Sayegh, lots of his clients didn't have money to pay for procedures. So what he did is he actually set up a loan company. Well, set up his clients with a loan company. In fact, if you go on his website, there's a number of loan companies on his website. And he essentially tells the patients, it's okay if you can't pay. We'll do payment plans with you. We'll get you a loan. And in fact, the year before our incident happened, he advertised on Facebook that he had more than $1.4 million in receivables from the loan company, or from one loan or multiple loan companies in the previous calendar year, not to mention, other credit card payments or any other, self-pay. So my client got to the procedure, or to the plastic surgeon, and he's recommended that she go forward with the case, said that she was a candidate for it, and set her up with a loan. and got her through a loan through this place called Alfie on Credit. She put about $2,000 some odd dollars down and then ended up financing the rest of a $12,000 plus surgery. Like I told you, Sayeg ends up flying in and out of Chicago and Detroit, and he's here for a couple days and then goes back to Detroit for a couple days. I think the evidence in the trial demonstrated that on the day of our surgery, it was his intention or plan to return to Detroit. So what did he do? He had my client show up for surgery at 4 a.m, believe it or not, and got her there at 4 a.m, and she underwent a tummy tuck liposuction, and as a result of complete medical neglect on behalf of Sayeg and his entire staff, my client ended up bleeding to death over the course of the next 20 plus hours, and she died.
And he had a track record of causing injury and death to other patients before this, right?
So when we got involved with the case, we obviously did our investigation, and from a casual outlook, I'll tell you, and I think everybody else has already figured it out, looking at my ugly mug on the screen, I'm not a plastic surgery person. I've never gotten plastic surgery. I probably never will. Actually, I could say I never will.
Don't sell yourself short, man.
No, there's only so much you can do with what God gave you, and I'm okay with it. What I was always of the belief is nobody should die during elective cosmetic surgery, right? So the case comes to us and we find out that she dies. And I think to myself, like, well, is this a rare case? Is there something funky involved here? Did she have, a fat embolus or a pulmonary embolism or some reason that isn't negligence, but, would explain why she died? And we took the case. I had a strong suspicion there would be a case. We investigated, got the records, got the death certificate. But more importantly, we looked at the filings in Illinois. And over the course of time, from the time Dr. Sayeg came to Chicago until now, he'd had a number of different deaths involved. And it was really kind of spooky because, like, you look up a doctor, you might see they had one lawsuit, maybe 2 lawsuits, and that might tell you something, but overall, maybe not, depending on the profession they're in or the practice. But when I look it up, and he had been in Chicago for just a short period of time, and over the course of time, he had, I think, six different lawsuits, or maybe even 7 different lawsuit filings, including a number of different deaths. I began to really question what was going on with this practice because something just seemed really off. And, I think there's a statistic you'll hear that 1% of physicians make up like 33% of all claims. Isn't that a crazy statistic? 1% of physicians make up 33% of claims. So I was thinking to myself, this has to be one of these people. So what I did in getting prepared in the case is tried to see if there was discipline. Like, if you have all these different cases with multiple deaths, that probably shouldn't happen in elective cosmetic surgery. Maybe he'd been disciplined before. In Illinois, discipline on your license is admissible. So we started to do some investigation. It turns out in Michigan, he had been sued a number of different times. I don't have the exact quote, and I don't want to misstate it, but he had a number of other lawsuits in Michigan. I'm like, this guy's got all these problems in Michigan with lawsuits. He's got all these cases in Illinois. Let's see if he has any discipline. And lo and behold, we learned he'd never been disciplined in Illinois. And that was very shocking and a little bit scary to me that he was doing this high volume practice and had never been disciplined with a number of deaths and a number of lawsuits. And at that point, I actually knew what that meant. In Illinois, the only time a doctor will get investigated by our state licensing board is if there's an adverse judgment or a settlement. At that point in time, I knew he hadn't been disciplined because he hadn't been hit yet. He hadn't settled, or he hadn't been found guilty on a verdict. So I started to dig a little bit deeper. And if I'm going on too long, just stop me. But deep dive found out that by the time we got to trial, we were his 3rd trial in the same year. Sayeg had been sued for causing the death of a patient, went to trial, and believe it or not, got a not guilty on his first case. His lawyer is a really good lawyer in Chicago, and he did a great job defending the case, got a not guilty. The plaintiffs, I don't remember who tried the first case, but the plaintiff's lawyer was not successful in getting justice for his client. Concerning for me. A few months later, he went to trial again, and the case hung. They couldn't convict or get a guilty verdict against Dr. Sayeg. It was really concerning for me. So by the time our case got set and scheduled for trial, I was on a mission to make sure that we got justice for my client and their family, and to make sure that we really accomplished 3/4 major goals. The fourth goal was something hopefully I'll talk to you about a little bit later, but the real three goals that we had for the trial was, number one, to get a favorable judgment and to get some justice for the family, because that obviously is the purpose of the lawsuit. Number two is we wanted to get a favorable verdict so that it would raise public awareness about Dr. Sayegh, so that when people were seeing his ads all over the internet, if they did just a simple Google search, they would find out that his background may not be exactly the way he advertises it on the internet, and that they should know that he's had at least one serious death involving negligence in the past, and maybe others. And then three, with an adverse ruling, what we really wanted was an investigation into his license for the state to do their due diligence and to see and investigate what actually is happening at that office, where there's a number of deaths and what has been alleged to be malpractice coming out of his office. And those were our real three goals of moving forward with the trial. And a fourth goal is, it turned out that through the evidence, we learned that Sayegh was doing plastic surgery out of his office without a license to do so. However, in Illinois, you can do general surgical plastic surgery from a plastic surgeon's office without a specific license to do so. And kind of what I said was our fourth mission on the case is we're going to try to change the law to get some additional oversight on these plastic surgeons doing general anesthesia big cases at their office in a non-certified ambulatory surgery center. And that's kind of our future goal. Once we get 1, 2, and 3 taken care of, we're going to turn to goal 4 to see if we can get some change in the law. I know that was a mouthful. I'm sorry.
No, it's a fascinating story, and it's a triumph of your hard work and the civil trial process to be able to get some justice for your client and to hopefully change the world and prevent this guy from harming other people down the road. So I know it's all pretty recent, so maybe you can come back once all of this plays out more and you can tell us how it ended.
Oh, that would be terrific. The current state of affairs is that there was a settlement that took place with the anesthesiologist while the jury was out. One of our allegations against Sayegh is that he was institutionally negligent, which in Illinois is that his business was negligent, not just how he acted through his medical actions, but that he was negligent in hiring an anesthesiologist who had actually ended up failing her board certification exam 5 different times and wasn't able to just take the exam again. So she was not board certified or board eligible anymore, and that the only way she could have went back for board certification and board eligibility was to be retrained through a residency or training program, and then she'd have to have retaken the test. And the reason why she ended up being there is he ended up paying her, a pittance on a daily stipend or a daily amount of money, instead of having what we thought would be a truly and properly qualified and trained anesthesiologist, of which the jury did find in our favor on that there was institutional negligence, and they also found the anesthesiologist to be professionally negligent as well.
Have you listened to the Dr. Death podcast series?
No, I haven't. Sounds like I should.
Oh, you should absolutely do that. But this sounds quite similar to some of the stories they tell on that show.
There's post-trial motions on the case, and we've got collection actions started right now. We've actually done third-party citations against all of his financing companies, so they can't provide him any funds currently without there being leave of court, because they're all kind of tied up in the collections action. With any hope, somewhat short period of time, at least stage 1 of the case will be accomplished, and we can move on to some of these other goals that we have.
Well, great work. I think we've reached our hour here. We could easily keep going. I know Rahul has to scamper off to trial, though, or court, right?
Unfortunately. I love hanging out with Brad.
Thanks so much for doing this. We really appreciate it.
I know it's a podcast, but I feel like I just blabbed on the whole time. So I apologize for anybody who made it this long in the podcast. My apologies for talking too long. Unfortunately, I don't get paid by the word, though.
Fortunate for us. No, I'm kidding.
No, you were great. You were great. It's compelling stuff to listen to. So just happy to sit back.
Hey, if anybody needs to reach you, Brad, how do they reach you?
Oh, they can reach me through email at Clifford Law. My email is bmc@cliffordlaw.com. and the office line is 312-899-9090. Email is probably best.
Thanks so much, Brad, and looking forward to having you back on the show too.
Thank
Thank
you.
you very much, guys. I'll be happy to see you down in Nashville.
Looking forward to that.